Hello students, welcome to Recitals in Depth. In this episode, we are going to discuss the topics covered under the section of Polity and Governance for the month of October 2024. The topics that we are going to cover are broadly falling under the broader themes of criminal justice system, important governmental schemes, various judgments by the Supreme Court or High Courts of our country, legal doctrines, and lastly, key legislations. Stay tuned. So the next topic for our discussion is right to unionize. So now let's try to understand that why we are trying to learn this particular topic. So the topic was right to unionize. So recently, as we already know that the electronic giant that is Samsung, which is a South Korean industry, so this had opened a very mega factory in the state of Tamil Nadu, to be precisely at Chennai. Now what had happened that the workers who were working in this particular factory which is manufacturing smartphones, now they went on to a strike. And ultimately, in a situation where entire governmental policy is focused towards attracting more and more investors in the manufacturing sector with respect to the Make in India initiative, or whether be it the PLI initiative, that is production linked incentive initiatives for this, whether be it electronic manufacturing industries or the semiconductor sector. Now in that case, when the workers who were employed in this particular Samsung factory, they went on a strike, and this strike almost continued till 37 days. Which is a good amount of days to actually obstruct any kind of manufacturing activity which is taking place in that particular factory. So definitely this kind of logjam between the employees and the employers is not only healthy for the employees because they are losing their wages, and secondary, it is definitely not good for the employees or the employers, that is the Samsung, because ultimately they are losing on their revenues, because ultimately if the work is stalled for 37 days, almost close to 1.3 months, ultimately Samsung is going to lose revenues. So that is why what we need to understand from this particular topic, from the polity's point of view, is that why the workers were actually on the strike. So ultimately the reasons were three. Firstly, they were trying to assert their right to unionize, and that is the key concept that we want to learn through this particular discussion. Secondly, they wanted to negotiate the terms of their employment. What do we mean by terms of employment? It can be various facets. For example, wages. What kind of wages are these people getting? What kind of safety regulations are there within the industry premises? What kind of social security benefits the workers are deriving from the Samsung? These are known as the terms of employment. And the third important aspect for which the strike was conducted by the workers at the factory site of the Samsung was that there was a recently formed workers union by the name of Samsung India Workers Union, SIVU for short. And what the workers were claiming, that this SIVU was not getting recognized by the state authorities. So these were the core demands for which the workers ultimately decided that they should go for a strike. And ultimately this strike lasted for 30 days. And as we already noted, that any kind of strike or a logjam between the employers and the employee in manufacturing setup is healthy for the neither of the parties. Ultimately, both of the parties end up losing on the revenues or their incomes. So these were the core 3 points. And now let us try to understand that why this SIVU or the Samsung India Workers Union was not getting recognized by the state authorities, and what are the various processes involved with the registration. So now let us try to understand the reasons why the SIVU was not getting recognized. So the first reason for it was the trademark objections. Trademark violations. So According to the management of Samsung, according to the management of the Samsung factories, what these people were putting forward their point, these people were of the opinion that the CIVU cannot use the term Samsung, that is the name of the company, while forming a union by the name of Samsung India Workers Union. And since this term CIVU has the term Samsung in its entire name or the full form of it, ultimately what the management of the Samsung claimed that it is leading to the violation of trademark, because these people contended that ultimately the term Samsung forms their trademark, and because the CIVU is involving the term Samsung in their complete name, it is going for brand dilution. That is, by using the name of Samsung or the symbol Samsung in their entire full form of the trade union, ultimately it is leading to brand dilution and brand misrepresentation. And Samsung wanted to keep themselves aloof from any kind of brand misrepresentation, or any that they did not want that their name should be used in formation of any kind of workers trade union. However, one more important point that we need to note over here is that ultimately the law which governs the trademark in our country is the Trademarks Act of 1999, and under the section 29 clause 5 of this particular act, it prohibits usage of a particular trademark by any other entity. That means that any particular entity cannot use the name of Samsung in promoting or marketing their product. That is very clear. However, what we need to note from the Trade Union Act of India of 1926, TUA for short, Trade Union Act 1926, it says that trade unions are non-commercial entities, which means that trade unions can be very easily will be able to use the term Samsung, and ultimately it will not violate the Trademarks Act of 1999. So this claim by the management of the Samsung was not founded to be correct. Now the second important point which we need to note over here is the process with respect to the recognition of any trade union. Now, as we know that the formation or the recognition and registration of trade unions in India and their functioning in our country is regulated under the Trade Union Act of 1926. And under the Trade Union Act of 1926, it provides for certain provisions with respect to the registration and ultimate recognition of such trade union. And what does these provisions say? So first of all, the Registrar General of Trade Unions or the Labour Commissioner of any state is the empowered authority to receive applications from any association, from any body or association which wants to be registered as a trade union in our country. And as soon as the Registrar General of Trade Unions or the Labour Commissioner of a particular state receives an application from a body or an association which wants to be registered as trade union, that particular Labour Commissioner will examine and scrutinize that particular application, and after proper due scrutiny, it provides the recognition. However, why the Samsung workers were on the strike? That they were claiming that the state governmental bodies were not providing them due recognition even when they have provided for the application to the concerned official. However, the state had argued that the state is considering the application form which has been provided by CIVU or Samsung India Workers Union so that ultimately after due examination and scrutiny, that particular body or governmental body will provide them with due recognition. So this was all about the process related to the recognition and registration of trade unions in our country. However, what we need to recognize and learn about a very important concept is what do we actually mean by right to unionize. So ILO, or the International Labour Organization, it defines right to unionize as a right of employees to do what? To organize themselves. Organize themselves so that they can engage in a very important concept, that is, they can engage in collective bargaining. And what do we mean by collective bargaining? Collective bargaining is a phenomenon where various employees come together, they form an association, and after forming an association, they actually articulate what is the best condition for them, like what kind of wages do they need, what kind of safety regulations do they need in the working of a factory, what kind of social securities do they need from the employers whom they have employed, and so on and so forth. And ultimately, collective bargaining is nothing but a process of collective negotiation. And as we already know that the negotiation always comprises of two major stakeholders. One is the employee or the employer, and second is the employee. Now, ultimately, as we know that an individual employee always finds it difficult to negotiate their terms of working with the employer, and that is why different employees, different individual stakeholders or individual employees, they come together to form a association, which is also called as trade union. And this trade union will try to articulate the needs and aspirations of the employees, and they will be able to put it forward with respect to the employers. So that one of the biggest element or the benefit of forming a trade union is that it provides a balance of power. That is, as we already know that, and it is very difficult for a particular individual to negotiate with an employer which is very profound and very powerful. However, if these employees who are individuals can aggregate themselves or form an association, ultimately it provides for a more balanced approach to the power. So ultimately now the employers and the trade union, they are almost at the same pedestal of the power, and when there is a power symmetry, then only there can be a balanced negotiation, and then only it will result into better outcomes. And that is why the ultimate final result of collective bargaining is collective agreement. And collective agreement is usually beneficial for both of the stakeholders. That is, who are the stakeholders? The employers and the employees. So that ultimately the collective agreement should be designed in such a way that the employers should be able to garner more and more revenues through the profitable venture they are performing, and secondly, the employees who are actually selling their labor to the manufacturing parties, the employees should be able to get more remunerative wages, better working conditions, more safety and social securities, which is quite due to them. So this was all about the collective bargaining and the right to unionize. However, from a constitutional point of view also we need to understand it, that Article 19, Clause 1, Subclause C of our Constitution, it provides for right to unionize. That is, it forms under one of the right to freedom, that you are free in our country to form associations or unions. And that is why it is very important from this point of view that whatever was happening in the state of Tamil Nadu, where the CIVU was not getting recognized or registered, it was in a way partial violation of their fundamental right of Article 19, Clause 1, Subclause C. So this was all about the right to unionize. However, in the pursuit of asserting their right to unionize, ultimately the workers went on a strike. So what do we actually mean by strike? So most of the democratic countries plus the International Labour Organization also, it recognizes strikes as a form of labor representation itself. That it is one of the methods in which labor will try to assert their choices over the employers. Now, as similarly as India is also a democratic country, so similarly the Supreme Court in its various judgments, Supreme Court has also highlighted that strike is nothing but a kind of demonstrations by the workers to actually put forward their demands in front of the management. Now, what kind of other demonstrations are also there? For example, absenteeism. For example, just like to show their that the workers are disgruntled or dissatisfied, discontented with the management of a particular company, the workers can decide to go for a mass bunk. For example, the workers will not show up for work in a particular day which was pre-decided, so as to show to the employers or the management of that particular firm that their demands need to be heard by them. Or secondly, rule to work. For example, whatever work has to be done, it will be done by very rule, and the workers will be doing it very dispassionately, not very emotionally attached with the work. So these were the Supreme Court's recommendations or observations as well. Apart from it, right to strike is also legally recognized in our country. And what is the particular act through which it has been recognized? So there is a particular act by the name of Industrial Disputes Act of 1947. Now, this particular act recognizes the right to strike, however, with certain limitations. And what are those limitations? So the limitations is very clear. Now, according to the Industrial Disputes Act of 1947, it says that the workers or the trade union can go to strike only by providing a prior notice to the employers. And what is the proper condition for providing those proper notice to the employers? So ultimately, the notice for strike has to be given before 6 weeks before the strike can be convened, or 2 weeks after giving that notice. Only after 2 weeks of giving that notice, strike can start. So basically, through this instrument, the Industrial Disputes Act of 1947 is trying to provide certain time period for the management of that particular factory or any manufacturing industry to actually sit in with the trade unions and try to learn and know about the needs and aspirations of the workers, or try to know the reasons for which the workers are demanding to go into the strike. So this was all about the right to unionize and right to strike. However, what we need to understand is that when India is striving to become a global manufacturing hub through the Make in India and production linked incentive schemes, such kind of strikes show India in bad light for the other countries as well, because ultimately India is trying to attract a lot of foreign direct investment in the modern manufacturing. And when other countries will try to see that such kind of labor regimes is operational in India, where the rights of the labor are not being heard, and ultimately when the rights or the voices of the laborers are not being heard, labor has got only one choice, that is to sit in the strike. And ultimately, as we already noted, that such strikes are not helpful for both the factories or the factory owners or the employers and to the employees as well, and also to the overall manufacturing ecosystem or environment which Indian government is trying to foster. So this was all about this topic. Now let's come to the next topic, which is states have the power to make laws on industrial alcohol. Now, if you guys remember it quite vividly, that we have discussed this topic in quite depth, however, in the month of April. Now it's a very good opportunity for you guys to actually go into the YouTube playlist for the month of April under the Polity and Governance section. Just watch it before you actually go through this particular discussion. So now let's try to learn this particular topic. So what is the context? So ultimately that we had discussed in the month of April also, that Supreme Court 9-judge bench had been constituted to dwell on the fact that whether the state government is competent enough to regulate the functioning and the operations of industrial alcohol. So recently in the month of October, that Supreme Court 9-judge bench, in the month of April we had read about that this particular 9-judge bench is considering the overall dispute and the matter was sub judice, and now in the month of October the Supreme Court has provided its judgment. So what is the particular judgment? So Supreme Court's 9-judge bench has provided that the state governments are competent enough not only to regulate domestic beverages or alcoholic beverages, but state government is also competent enough to regulate matters related to industrial alcohol. Now before we go on to that, let us try to understand the core of the core tenet with respect to the legal dispute, that what is the particular legal issue for which the central government was fighting with the state of UP. Now ultimately the genesis of this particular legal dispute lies in the overlapping of jurisdiction of the powers of central government versus the state governments. Now as we know that the Constitution has provided the various powers and functions or the topics on which both the central government and state government can regulate, and this is codified in the 7th schedule of our Constitution. So the 7th schedule of our Constitution, it provides for 3 lists, that is the Union list. It enlists all the matters on which the central government can make laws. Secondly, the second list is called as the state list, and it comprises of the matters on which the state government can make laws. The third list is the concurrent list, and it is such a list on which both central government and state government can make laws. However, if there is a matter on which both the central government and state government have made laws and the provisions of the state government is in contravention to the central act of the central government, then ultimately the law which has been made by the parliament of our country will prevail. So this is the basic of how the 7th schedule of the Constitution has been designed, or the institutional designing which has provided for the union list, state list and the concurrent list. However, what the dispute pertains to is that there are 2 contravening entries in the 7th schedule. Firstly, in the entry 8 of state list, it provides for the matter of intoxicating liquors. Intoxicating liquor. So ultimately it provides for the state government to regulate all the matters related to intoxicating liquors. However, there is also an entry by the name of entry 52 in central list. Now this is a very important and a very interesting entry in the central list. What does it say? It says that the parliament by law can empower the central government to regulate any industry in public interest. Now imagine what can the abuse of entry 52 can lead to the intervention of central government into the legitimate powers of the state government. Let us try to understand this particular facet. Now, as this particular dispute is pertaining to the industrial alcohol and not alcoholic beverages, there are two kinds of alcohol. One is for human consumption, which is also called as alcoholic beverages. And secondly, there is industrial alcohol. So the first, what does the state government is contending in this particular dispute in front of the Supreme Court? State government is of the view that since under entry 8 of the state list, it enlists intoxicating liquor, what state government is contending that both industrial alcohol and alcoholic beverages which are meant for the human consumption will come under the entry 8 of the state list, and through this logic it empowers the state government to regulate all the processes with respect to the sale, supply and transportation of industrial alcohol with the state government. However, what has done with the Act of Entry 52 in the central list, which empowers the union government by an act of the parliament that union government can regulate the matters of any industry in public interest. So utilizing this power of Entry 52 of the central list, what the parliament had done is that it had created an act by the name of Industrial Development and Regulation Act of 1951, and under section 18G of this act, it provided powers to the union government to regulate industrial alcohol, so we can see two branches of power branching out so as to regulate the same sector of industrial alcohol. So there are two questions. First of all, whether the intoxicating liquor, which is usually understood as the alcoholic beverages, also contain industrial alcohol. So that is the argument of the state government. State government believes that this term intoxicating liquor contains both part of the alcohol, that is the alcoholic beverage which is meant for human consumption and the industrial alcohol. Since industrial alcohol is also alcohol, however, industrial alcohol is made by adding certain chemicals like benzene and pyridine so as to make it non-palatable. Non-palatable means it is unfit for human consumption. Unfit for human consumption. And ultimately, why does the state government wants to regulate industrial alcohol? Because ultimately it is a great source of revenue to the state government. And secondly, this industrial alcohol is also utilized in the manufacturing of spurious liquors. That is, many times we come across in the newspapers like that the cases of hooch or the hooch tragedies, that it has been reported in various newspapers that hundreds of people had died or died of various kind of poisoning due to the illegal liquor which was prepared using the industrial alcohol. Now industrial alcohol, since it already contains harmful chemicals like benzene and pyridine, what the antisocial elements who manufacture such illicit alcohol they does is that they divert the industrial alcohol and they sell it to the local crowds or the marginal crowds who are living in the slums of our country in very cheaper price, and ultimately through this many a time accidents have happened where people have lost lives. And that is why state government is trying to regulate or trying to look to regulate the industrial alcohol because of the revenue it is providing, and secondly to provide any kind of mishaps with respect to the spurious alcohol. And for the same logic, central government also wants to regulate industrial alcohol. Why? Because ultimately central government would be wanting to raise revenues from the selling of industrial alcohol. And that is why central government, with the help of Industrial Development and Regulation Act of 1951 and the section 18G, which provided the power to the central government to regulate the functioning of all the processes related to the sector of industrial alcohol. And this was the constitutional conundrum which was in front of Supreme Court of our country. And ultimately, what did the Supreme Court rule? Now let's try to understand it. So as we already noted that state government was contending that ultimately alcohol comprises of alcoholic beverages which is meant for the human consumption, and secondly industrial alcohol as well. Now state government and central government had different viewpoints. State government contended in front of the Supreme Court that alcohol or the intoxicating liquor, which was the entry 18 of the state list, comprised of both the alcoholic beverages and industrial alcohol. However, what central government had contended that the intoxicating liquor which is present in the entry 18 of the state list, it comprises of only beverages and not of industrial alcohol. However, what the Supreme Court ruling of the 9-judge bench held was that it enhanced or broadened the definition of the entry 8 of state list. That is, the Supreme Court judgment or the 9-judge bench, it broadened the definition of intoxicating liquor. And what did the Supreme Court say? Supreme Court ruled that ultimately the intoxicating liquor will comprise of both the alcoholic beverages and the industrial alcohol, because ultimately it does not matter whether both of the entities, whether be it the alcoholic beverages or be it the industrial alcohol, whether they are fit for human consumption or not. But what is more important is whether they are intoxicating. And from that logic, both alcoholic beverages and industrial alcohol, since ultimately they are alcohol only, and since they are alcohol, they are intoxicating. And through that logic, Supreme Court ruled that ultimately the intoxicating liquor term which is present in the entry 8 of state list will comprise both the industrial alcohol and the domestic beverages, which basically logically given the authority or the power to the state governments to regulate the processes related to the industrial alcohol. So this was the first important ruling or the judgment which has been provided by the 9-judge bench. The second important aspect which the Supreme Court dealt was with the federal balance. Now, as we already discussed, that the entry 8 of list 2, that is the state list, and the entry 52 of list 1, that is the central list. Now, with the help of the entry 52, the central government in that case will be able to intervene in the functioning of any industry. This industry can be any industry which ultimately can fall under the regulation or the jurisdiction of the state governments. And the Supreme Court noted that just because entry 52 has been provided, and if Parliament felt that for the public interest it can provide through a law that central government can also intervene in that industry, then in that case it will render the entry 8 redundant. And such kind of interpretation of the constitutional scheme will ultimately demolish our federalism, demolish the federal integrity of our country. So, which means that ultimately Supreme Court ruled that whenever an interpretation of entry 8 and entry 52 has to be done, or whenever interpretation of entry 52 of union list has to be done, it has to be done in the light that it maintains the federal autonomy. and entry 52 cannot be used as a tool by the union government to intervene into the legitimate subject matters of the state government, as union government had done in the matter of intoxicating liquor. That union government used the entry 52 to make a law, that is the Industrial Development and Regulation Act, so as to provide the power to the union government to regulate or intervene into the legitimate matters of the state government. And to maintain the federal balance of power and to maintain the federal integrity of our country, Supreme Court ruled that whenever the interpretation has to be done, whether entry 52 can lead to the intervention in the state list, it has to be very cautious with respect to the interpretation, and care has to be taken so as to maintain the federal balance as well. And this is a very, very important judgment by the Supreme Court of our country, which is restoring the federal balance of it as well. So this was all about this particular topic. Now let's come to the next topic, which is again a very, very interesting and legally bit nuanced topic. So what is the title of this particular topic? Lawrence Bishnoi Interrogation. So now let's try to understand this particular topic. So what is the context? So in this episode itself, we have discussed a particular topic, that is the bone ossification test. And in the bone ossification test, the context was the killing of a former MLA, that is Baba Siddiqui at Mumbai. So same context we are studying over here. So what had happened, as we noted, that the MLA was murdered and after investigation, Mumbai police nabbed down 2 accused. And these 2 accused persons, they had a link with Lawrence Bishnoi gang. Now, who is Lawrence Bishnoi? So apparently Lawrence Bishnoi is a very notorious gangster and who is presently lodged in Sabarmati jail in Gujarat. Sabarmati jail in Gujarat for drug smuggling. And this Lawrence Bishnoi has earned a lot of disrepute with respect to a lot of killings, and recently shots were fired outside the house of megastar Salman Khan as well, and for which the Lawrence Bishnoi gang had taken the responsibility. So the 2 primary accused who has been nabbed by the Mumbai police, and Mumbai police is trying to interrogate them, it showed after their investigation that these 2 accused are having links with the Lawrence Bishnoi gang. And this Lawrence Bishnoi person is currently lodged in the Sabarmati jail of Gujarat. Now the Mumbai police wanted to interrogate Lawrence Bishnoi with respect to the killing of Baba Siddiqui. They wanted to get more information and gather more evidences with respect to the whatever scheme they had made for the killing of Baba Siddiqui, that is the former MLA. However, what came across to the Mumbai police was that the Mumbai police was not given orders by the court to retrieve Lawrence Bishnoi out of the jail, and court ordered Mumbai police that they should go to the jail and interrogate Lawrence Bishnoi. So usually it happens that investigative agencies, whenever they want to interrogate any particular individual, they will retrieve that individual and they will put into their own custody and they will try to interrogate. However, in this particular case, court ordered the Mumbai police or any investigative agency that ultimately they should go into the jail premise and then only they should be able to interrogate Lawrence Bishnoi with respect to the murder of Baba Siddiqui. Now, this is a core issue which we need to learn in this particular topic. Like what are the various important critical legal nuances which are associated with such kind of procedure. So now let's start to understand this particular topic. So we have to begin with CRPC or Section 267. So what does the CRPC Section 267 say? It authorizes the court to ensure physical attendance attendance of an accused during trial in court to ensure what? To ensure free and fair trial. Free and fair trial. So basically it means that whenever accused has to be going through a trial, so the accused has to be brought in front of the court or front of the judge, so as to make sure that the trial is free and fair, and the aggrieved person or the accused person over here, whether the accused will be convicted or not, it is a matter of time and fact which has to be scrutinized by the judge. However, the particular accused has to be brought in front of the court so as to ensure free and fair trial. However, this is the normal course of action which is prescribed by the section 267 of Code of Criminal Procedure, that is the CRPC. However, if this is the normal code of conduct, why then in the case of Lawrence Bishnoi, the court ordered the investigative agencies that ultimately you guys have to go to the jail premises and you can interrogate Lawrence Bishnoi only within the jail premises? And the answer to it lies in the ultimately Code of Criminal Procedure section 368. So what does this CRPC section 368 suggest? So it says that it authorizes, basically section 368 authorizes the state government or the central government to restrict movement of a specific individual or a group of individuals out of the jail premises for any purposes with respect to the trial or interrogation or any other proceedings. Which means that with the help of section 368 of the CRPC, it authorizes the state government or the central government to issue any notification which can restrict the movement of an individual or a specific group of individuals to go out of the jail premise to be present in any trial or any interrogation or any proceedings. Using the same power which has been provided by section 368 of CRPC, in August 2023, Maharashtra state government had issued a notice for application of the same section 368 for Lawrence Bishnoi, which basically restricted the movement of Lawrence Bishnoi outside of the jail premises. Okay. And similarly, as we know that Government of India recently basically replaced IPC and CRPC with Bharatiya Nyaya Sanhita and Bharatiya Nagrik Suraksha Sanhita. So the section 368 which was codified in the CRPC is known as section 303 under the Bharatiya Nagrik Suraksha Sanhita. So the substantive element of the law remains the same. However, the numbering of the proper section has changed while we have moved from CRPC to the BNSS. And with the help of BNSS section 303, this particular notice was extended for one more year in the August of 2024 itself. Now we need to understand that what is the criteria for application of such kind of notices which restricts the movement of a person outside of the prisons. So section 303 clause 2 basically identifies three important elements or three important criterias for the implementation of such notices. So first is the nature of offense. So usually it has been observed that if the nature of offense is quite heinous, government of any state or government or the union government tries to issue such kind of notices under section 368. Secondly, if the government feels that if a person who is accused of a very heinous crime, say for example rape or any terrorist activity, if they come out of the jail for any trial or if they come out from the jail for any parole or furlough or for any kind of investigation, there is a threat for the larger public disorder, then Government of India will try to issue notices or directions under the section 368 of the CRPC. And lastly, if the government is convinced that it is better for the public interest, larger public interest, that the particular specific accused person is better to be put in jail and it should not be allowed to intermingle with the society, and in the pursuit of larger public interest, government can issue orders or notifications under section 368. But what do we need to also understand, that what is the primary purpose of issuing such kind of notifications? So firstly, the security reasons. What security? That the government feels that if that primary accused person who has gone in violation of a law in a very heinous manner, for example, Ajmal Kasab, or for example, there are many rape accused or convicts. So they have committed a lot of heinous crimes, and ultimately when they will come out of the jail for any kind of interrogation or for to the court trial room, ultimately it can pose their threat to life. So such movement outside the jail premise will be a very good threat to their own life, and ultimately it can be a threat to the life of witnesses as well, because if a particular accused person has got a lot of sway or political connections, they would want to threaten the life of witnesses who are trying to prove the particular accused person to be a convict. And the second is to deny parole, or furlough to such kind of individuals. And similar kind of situation which is there for the Lawrence Bishnoi, similar kind of situations was there also for the Ajmal Kasab, who was involved in the 26/11 2008 Mumbai terror strike. Okay, so this was the legal nuances associated with the interrogation with respect to the Lawrence Bishnoi. Now the next topic for our discussion is Indian Council for Cultural Relations. So now let's try to understand it. So what is the context? So recently, Indian Council for Cultural Relations, ICCR for short, it convened a conference in Colombo, which is the capital of Sri Lanka, and it invited a lot of Buddhist monks from all across the world, Buddhist monks and scholars, so as to deliberate on the fact that Pali should be given the classical language status in India. So in this context, let us try to learn more about the Indian Council for Cultural Relations. So this ICCR was established in the year of 1950. It goes way back, and it was established by Maulana Abul Kalam Azad. Who happened to be first education minister of our country. Presently, this Indian Council for Cultural Relations is working as an autonomous institution under the Ministry of External Affairs, with the primary motive to promote India's external cultural relations by increasing more and more exchanges with other countries, their culture and people. So secondly, that is the primary motive, and the method it is trying to use, that it is trying to leverage the soft power of our country. What do we mean by soft power? Soft power are those elements of our foreign policy which tries to influence the decision making of other countries, or how there are certain elements of our own cultural tenets or society which tries to mold the perception through which other countries views us. For example, literature, arts, cinema, yoga, are important tenets of India's soft power, through which India is trying to create a good and a fundamental mark with respect to how the world sees us. It is very important that how we are should be perceived in our in the entire global order should not only be dependent on the economic prowess of our country, but also the soft power or the intangible elements of our cultural heritage. And that is the primary motive and the method which the ICCR is using to promote India's external cultural relationships across the world. And what are the core objectives which the ICCR is trying to achieve? So first of all is policy formulation. So ICCR plays a very fundamental role in forming various kind of policies which will promote and increase India's cultural exchanges. It is the nodal body to create such kind of policies. And secondly, to increase India's external cultural exchange and relations. And how the ICCR is trying to achieve the second objective? Firstly, it has created Indian cultural centers across the world in various important cities. For example, in the cities of New York or Tokyo, Berlin, etc. And ICCR has established these Indian cultural centers, which becomes the hubs or the nodes for cultural dissemination. What do we mean by cultural dissemination? That imagine a situation that there is a good organization by the name of Indian Cultural Center in the city of New York, and every Saturday there are various kind of events which are being organized in that Indian cultural sector, which is portraying nothing but various facets of Indian culture. Sometimes they are conducting any kind of function on Indian dance, say for example Bharatnatyam, or sometimes they are conducting function on Indian music, for example, so on and so forth. And secondly, they are also coming up with magazines called Indian Horizon, in which it talks in depth about the evolution of Indian culture and how the culture is still thriving in our country. Apart from it, ICCR also has the primary and fundamental responsibility that it should try to pervade the various tenets and philosophies of the Indian culture. And how we can do that? ICCR will be able to do that only through attracting more and more foreigners to come to us and learn our culture. And for that thing, ICCR is also providing various kind of scholarship programs. And through the help of those scholarship programs, thousands of foreigners are trying to come and learn our own languages, literature, music, dance techniques, etc. So in this way, ICCR administers various scholarship programs, awarding 3,000 scholarships under 21 different schemes to foreign students from approximately 180 countries. Out of which 6 are funded directly by the grants of ICCR and rest are provided by the Ministry of External Affairs. So in this way, Indian Council for Cultural Relations is playing a very important role in positioning India not only in a very hard power way, but also leveraging the soft power of our country so as to make India a very important power in the global world order. So this was all about this topic. Now next topic for our discussion is abetment of suicide. So now let's try to understand this particular and learn this topic. So what is the context? So recently the Supreme Court had provided in a judgment that it had cautioned the courts and the investigative agencies as well to avoid any kind of unnecessary prosecution of people who are accused in abetment of suicide under workplace conditions, or the cases which are stemming from the workplaces. So what is the particular background of this particular case? So there was a person by the name of Rajiv Jain who was a salesperson in a particular company. Now what happened is that the senior management of that particular company they advised Rajiv Jain to take voluntary retirement scheme or the VRS in year of 2006. And apparently it was also said that the senior management had threatened Mr. Rajiv Jain, who was a salesman, that if he will not take VRS, and the senior management threatened that if they will not take the VRS, ultimately they will demote him. Such kind of threat in the office or the workplace ultimately caused a lot of stress and anxiety to Mr. Rajiv Jain, who ultimately took his life by suicide. And there was a brother of Rajiv Jain by the name of Rajneesh, and Rajneesh had sued the senior management officials as culprits to the suicide of which has been done by his brother as abetment of suicide. So in this topic, we are going to understand the concept of abetment of suicide and what has the Supreme Court ruled in the previous instances also, under what conditions Supreme Court actually involves persons or prosecutes persons who are involved in similar kind of cases. So now let's try to understand the first concept, which is abetment. So first of all, we'll like to learn what is abetment, and then we'll try to apply the same concept in the abetment of suicide. So abetment is defined under the section 107 of the Indian Penal Code or the section 45 of the Bharatiya Nyaya Sanhita. As we know that the BNS replaced the IPC. So since all the crimes which are committed before 1st of July of 2024 are legally fought under the IPC and CRPC, and post that all the crimes are being fought under the Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita. So what does the IPC section 107 defines abetment? So a person abets of doing a thing, abets of doing a particular thing. It can be anything. Firstly, if that person instigates other person to do that particular thing. Secondly, if a person engages in any kind of conspiracy so that the other person will be able to do that particular thing. And the thirdly, if a person aids the other person to commit or do a particular thing. Now we need to apply these three conditions with respect to suicide also, and the IPC section 306 and Bharatiya Nyaya Sanhita section 108 deals with the section of abetment of suicide. The three conditions are legibly applied to the IPC section 306, and if a person is convicted of abetting of suicide if a person engages in these three elements, that is instigating the other person to commit suicide, secondly engages in a conspiracy that the other person end up doing suicide, and thirdly aids the other person in such a manner by providing certain things through which the other person can commit suicide. And the section 106, it provides that ultimately it's a non-bailable. Abetment of suicide in our country is non-bailable, cognizable and non-compoundable offence, and courts can give imprisonment up to 10 years. 10 years. And now let us try to understand what has the Supreme Court held in this particular judgment. So what the Supreme Court ruled is, the Supreme Court noted two very important things in this proper judgment. The first is, Supreme Court noted that a person can be convicted of abetment of suicide only when there is a direct incitement. That ultimately there is a direct intention is visible that a particular person wanted the other person to commit suicide. And secondly, the Supreme Court also ruled that there are two categories of cases and the court should be very cautious in dealing with two such categories of cases. The first category are the sentimental relationships or personal relationships. In this category of relationships, the Supreme Court held that the threshold to prove abetment of suicide is quite low, as we know that for any personal relationship or in a relationship where more and more emotions and sentiments are involved, it might be a situation that any kind of disagreement or a smaller fight or any kind of say disharmony within that particular relationship might lead to enhanced evocation of emotions, and sometimes it goes beyond control and people end up committing suicide. And that is why Supreme Court held that in cases of personal relationships or sentimental relationships are involved, the threshold to prove that there has been an abetment of suicide is quite low. However, the second category for which the Supreme Court asked all the courts and the investigative agencies to exercise more and more caution are the official relationships. Now, as we know that the sentimental relationships or the first category of relationships, they are governed more by the emotions of love or hatred or anger. However, the official relationships are governed more by the workplace culture, laws, norms, processes. And the Supreme Court held that ultimately, since all the official relationships works within the premises which has been set by the larger law and the norms and the various mechanisms and processes, the courts should be extremely cautious while prosecuting a particular person, and court should try to look for evidences, very concrete evidences which shows that a particular person has instigated another person to commit suicide. And if there is void of any such kind of evidences which is right on the face that one particular person has instigated or aided a person to commit suicide, then in those cases courts should avoid prosecuting or involving the names of such persons as an accused for trying for the abetment of suicide cases. So this was the primary observation by the Supreme Court of our country in this case. However, there are certain other important Supreme Court judgments also with respect to the abetment of suicide. The first important case is the Arjunan versus the state of 2019. Again, in this particular case, the Supreme Court ruled that there has to be a very concrete evidence of instigation to not to fight, but instigation to commit suicide, and mere fights, disputes or disagreement does not constitute to the abetment of suicide. So Supreme Court was very clear in this fact that even if two individuals are fighting, disagreeing or are involved in any kind of a tussle, that kind of a disengagement or disagreement between two individuals does not commit for the abetment of suicide unless there is a very concrete evidence that one party to the dispute is instigating or pushing another person to commit suicide. The second important case which actually deserves our attention with respect to the abetment of suicide is the Uday Singh versus State of Haryana 2019. Again, in this case, Supreme Court had held that every cases concerning with abetment of suicide should be dealt with according to the facts of that particular case. And in this way, what it means is that every situation, for every case of abatement of suicide, it will be very difficult to actually ascertain whether there has been a concrete evidence with respect to the instigation of instigation or abatement of a suicide. For example, the Supreme Court in the Uday Singh versus State of Haryana had cautioned or had ruled that ultimately it has to be proved that because there was a tussle between two parties and the party won, left no other choice for the party to accept than the suicide. And if they can prove it with quite a certainty, then only the second person will be accused of abetting of suicide. So this is the Supreme Court's point of view with respect to the abatement of suicide. Now let's come to the next topic for our discussion is third party litigation funding. So again, it's a very important and a very interesting concept that we need to learn, which is trying to knock on the doors of our Indian legal landscape, and it is promising a lot of change. So now let's try to understand what do we actually mean by third party litigation funding, as it is quite inherent in the name itself, that is the third party. So this third party litigation funding, or TPLF for short, it's nothing but a kind of a financial arrangement. Financial arrangement which is provided to a plaintiff or a person who is involved in a particular legal dispute by a third party funder who is not a party of the particular legal dispute. Now let's try to understand this particular concept with a very simple diagram. Now imagine there are two persons, 1 and 2, and these two persons are involved in a particular legal disputes. Now imagine there is a third person by the name of number 3. Now these two individuals are involved in a legal dispute, and as you already know that courts of our country is absolutely burdened with millions of cases, and ultimately a peaceful resolution or amicable resolution of legal disputes takes a lot of time, and secondly a lot of resources as well. And many a times it might be a possibility that this person number 1 is not able to pursue the legal cases with person number 2 because the number 2 person can be a very rich person. Number 2 person has the resources to keep on dragging the legal dispute in the courts of our country, and person number 1 does not have that much resources to actually claim what is due to him. So what does this third party litigation funding entails is that it is a financial arrangement where a third party or person number 3 provides funds to the person number 1 so that this particular person number 1 will be able to keep on fighting with person number 2 so as to claim what is actually legally due to him. And as soon as the particular person number 1 will win the legal dispute, now ultimately there will be an arrangement between person 1 and person 3, a pre-decided agreement, and whatever will be the claim that person 1 is getting out of this legal dispute, it will be distributed among person 1 and person 3 in pre-decided ratio. And that is what it stands for, the third party litigation funding. Now globally this is a well practiced fact, that is, it is in quite vogue and it is practiced worldwide, especially in the developed countries like USA, UK, Australia or Canada. Apart from that, it is also knocking the doors of India's legal fraternity, and it is being started practicing in India as well. However, in small cases, in small proportion. Supreme Court has provided a very significant ruling with respect to the functioning of TPLF or third party litigation funding in India in Bar Council versus A.K. Balaji 2018, where Supreme Court had held that TPLF is allowed in India till the fact or till the extent that lawyers are not funding. Lawyers are not party or funder to the dispute. Okay. So as we already noticed that since the practice of TPLF is already trying to make its ground in our country, however, what we need to understand is what is the need for TPLF or third party litigation funding. So as we already noticed or noted that fighting a legal battle in our country is extremely costly. It takes away a lot of wealth from the individuals and put a lot of people into the debt. And secondly, it is very lengthy, so that a person does not know when ultimately he will get to the final amicable solution to the legal disputes that they are pursuing. So the first point is ultimately to provide financial resources. So since the financial resources will be provided by the third party funder, so the plaintiff who is actually fighting for their own right or any particular property, they should not be worried ultimately, because they will be getting more finance or the financial resources to carry on with respect to the legal dispute. Secondly, it will be providing more access to justice. Now, since the proper achievement of justice is quite costly and it takes a lot of time, many people actually walk out of the legal cases and they do not their legally owned right, so that because ultimately they have to pay a lot of money and they have to invest a lot of their time as well. And that is why with the help of third party litigation funding, more and more people will be able to access justice, so that they will be able to pursue the claim over which on a particular legal dispute. The third is complex litigations. Now, as we know that with more and more technology and more laws, and the society is also changing, so the litigations are also getting more and more complex. And to win such complex litigations, we need more research and more talent, and for that talent we need financial resources, and ultimately these financial resources can be received from the third party litigation funding. So these are the basic need for which we actually need the third party litigation funding. However, it's very logical to actually assume what can be the benefits that we can accrue from the third party litigation funding. So the first is increased access to justice. It is very logical, because as more and more people will be able to access justice or access finances through this particular financial arrangement, more people will opt to fight their own battles in the court of law, and ultimately it will provide for more and more access to justice. Secondly, the benefits will be the plaintiffs will have financial relief, that the person who is fighting the legal battle, they do not have to worry about the cost they have to incur to win that particular battle. The third is, as soon as the funders will win the case, funders will also get a part of asset which was being fought over. So ultimately it will be profitable for the party who is funding as well. And thirdly, lastly, it is good for the overall pendency ratio of our courts as well. Because as more and more cases will come to resolution, ultimately it will lead to reduction of pendency in our country. However, there are certain inherent challenges and concerns also with respect to the actual functioning of third party litigation functioning. The first point that we need to note is the profit motive. That is, all the funders or the third party financial providers or financial resource providers, they will try to go for or fund only those cases which are having more profit. So ultimately the financial motives will any day will trump the social motives. The second important point that we need to note over here is the exploitation of plaintiffs. Exploitation of plaintiffs. How? Now, since there will be only limited number of people who will be trying to fund the various legal disputes which are going on in our country, and since there will be very limited amount of funders, so ultimately there will be very less supply of fund. And since there will be less supply of fund, the plaintiffs will have very lesser number of pool of funders from where they can get the fund to continue their legal dispute. And since there will be very lesser number of funders, ultimately these funders will arm twist the plaintiffs to design such pre-dispute contracts, and ultimately it will mean that as soon as the plaintiff will win the legal dispute, a greater proportion of the asset that they will control now will be transferred to the financial providers. The third important point which we need to note over here is that pre-settlement of disputes. Now, we should be very clear with one particular fact, is that the person or the third party fund provider is not bothered about the resolution of the dispute. They are only bothered about, their primary motivation is to make money out of the resolution of that particular dispute. These people are not bothered whether the particular plaintiff has received justice. It is only about receiving money. So what these fund providers will do is that they will again pressurize the plaintiffs to go for pre-settlements, so that ultimately they should be able to get more and more money out of this total financial arrangement. So overall, this third party litigation funding looks very bright for those people who are not able to access justice. However, there is a need, and is a very dire need, for the government to come up with very comprehensive and detailed guidelines, so that the interest of all the stakeholders in resolution of a particular dispute should be conserved, and it should not create such a situation where plaintiffs who are themselves indulged or absolutely trapped in the legal dispute, it will add to another layer of burden onto them. So this was about the third party litigation funding. Let's come to the next topic. MLA-LAD Funds, which is a short form for Member of Legislative Assembly Local Area Development Funds. So now let us try to learn this particular topic. So what is the context? So recently the Delhi government has increased the funds which are allocated to the MLAs under the Local Area Development Scheme or the fund from 10 crore to 15 crore annually. And this particular 15 crore annual allocation of funds to the MLAs of Delhi government is the highest in the country. So now, in the context that this particular fund which has been allocated to the MLAs has been increased, this make us to learn this particular topic. So now let us try to come to learn more about the scheme. So this MLA-LAD scheme is modeled on the lines of MP-LAD, that is the Member of Parliament Local Area Development Scheme, which is basically implemented by the Ministry of Statistics and Program Implementation. And under, just based on like the MP-LAD scheme, under this MLA-LAD scheme also, MLAs of a particular state are provided funds which are decided by the state government, and these funds are provided on an annual basis. And these funds are provided for the objective of development of their local constituency. Okay. Now, as we know that the state government is the primary authority which determines the quantum of the fund, and as we saw that the Delhi government has increased the annual 10 crore fund allocation to 15 crore. However, we also need to understand how this particular schemes is being implemented throughout the country. Although we know that the Delhi government is providing the maximum amount of funds through the MLAs so that they can provide for development in their local constituency, which is in line with the aspirations and needs of the people. However, what is the status of other state governments with respect to the functioning of MLA-LAD schemes? So, since we know that it is the state government which determines the quantum of fund to be given to the MLAs, there are two categories of state. Category 1, it provides for the implementation of MLA-LAD scheme. However, there are certain states, that is the second category, which don't implement such scheme. So, there are certain states which do not have MLA-LAD scheme. For example, Haryana, Punjab, Sikkim. Now, for the states who are actually implementing the MLA-LAD schemes, the amount which are being given to the MLAs, they vary from state to state. For example, let's take the case of central government, that is for an MP under the MLA-LAD scheme, they receive 5 crore annual fund which they can actually invest or try to provide for the developmental activities in their own constituency. Apart from it, we already noted that Delhi is providing 15 crores, UP is providing 5 crores, Arunachal Pradesh, for instance, is providing 55 lakh, and on the other hand, smaller states like Tripura is only providing 35 lakh. So, from here we can observe that there is a great heterogeneity with respect to the quantum of funds which are being allocated to the MLAs of a particular state, and all the states based on their own fiscal capacity are trying to provide funds to their MLAs which should not actually alter their own fiscal or the budgetary support, and the funds which are provided to the MLA is free to go for expenditure of those allocated fund based on their own discretion, which means that ultimately it will be the MLA under the MLA-LAD scheme, that it will be the MLA which will decide how it will be spent, and where it will be spent. So this was all about the details with respect to the MLA-LAD scheme. Now let us try to understand what are the various kind of projects which can be taken care under the MLA-LAD scheme. So usually, as we know that MLAs would want to use these funds for the development of their own constituencies, and usually such MLA-LAD funds are used for durable infrastructure work. Durable infrastructure works. And what do we mean by this durable infrastructure works? It comprises of building of roads, sewer networks, parking places, parks, shelter homes, beautification of their constituencies, etc. And ultimately, the kind of works which is being done with the help of the funds which has been provided to the MLA should reflect, ideally it should reflect the needs of the people of that particular constituency. And that is why ultimately, if the MLA is providing good work, and if MLA he is having good estimation of what do the people at the ground or the grassroots actually need, then MLA will be very easily able to use the funds to actually provide to the people what they really want, and ultimately it will increase the winnability factor of the MLAs also. And that is why MLA-LAD funds is a very important political tool as well, because it can make MLAs a very important viable instrument of good governance which is extremely localized in its scope. So now let us try to understand what are the major challenges which are associated with this particular scheme. Now the first important challenge which has been observed throughout the functioning of the scheme throughout the country is that the underutilization of funds. To give you certain context or an example to it, so for the year of 2020 fiscal, Karnataka was able to utilize only 32% of the MLA-LAD funds. And ultimately it led to lapsing of 68% of the funds which were provided to the MLAs. Secondly, misallocation of funds. Now since ultimately MLAs has to cater to the needs and requirements and aspirations of the people of their constituency. However, it has been noted and observed by various civil society activists and political observators that MLAs try to divert these funds towards vote bank politics. That is, putting this money in such kind of projects which is not attuned or aligned with the actual requirement at the ground. Thirdly, the usage of these funds, it goes through a greater degree of approvals by various district authorities, and as soon as district authorities will be providing approval, it will need approvals by the state authorities. And over and above that, there is a great degree of documentation of the work as well. And because of the documentation and the approvals which is required, ultimately it leads to a lot of delays in the implementation of such kind of projects. The fourth important aspect is the lack of awareness. Many a times the MLAs themselves don't know what kind of projects they can actually bring in under the MLA-LAD schemes, and which leads to poor selection of the projects and which basically are denied approval at the later stages. After that, fifth important point is poor planning and execution, which basically stems from the lack of awareness itself. Now, majority of the MLAs are not able to conceive the entire scope of the program or the project that they are conceiving, and since the planning is poor, ultimately it leads to poor execution, which leads to cost overruns, and ultimately it might lead to delays as well. Sixth point is lack of coordination and collaboration between various stakeholders. Now we need to understand that there are multiple stakeholders are there. One stakeholder is MLA, second is the district authorities, third is the implementing agency, and fourth are the electorate. Now, since different stakeholders are involved and there is very minimal communication and exchange of ideas among the stakeholders, ultimately it leads to lack of coordination and collaboration, which ultimately lead to decreased quality of outcome. And the last point is poor monitoring and supervision. Now this has been observed that there is no real-time MLA fund tracking mechanism, that ultimately people of a particular constituency should be able to view it in a very transparent manner, that when and where their particularly elected MLA is trying to expend the MLA fund which has been accrued to the MLA under the MLA-LAD scheme. So these are the various challenges which are associated with the functioning of the MLA-LAD scheme. However, the MLA-LAD scheme is, as we already noted, is a very potential scheme, because ultimately it has the potential to change how the governance is being conceived at the grassroots, because all the infrastructure which is created can be directly attuned or linked to the core demands of the electorate. So this was all about this particular scheme. Now the next topic is Overseas Citizen of India. Now let's try to learn this particular topic. So why we are bothered to discuss this particular issue? So recently a very interesting thing had taken place. So there was a fake news which was circulating in the social media. And what did that fake news say? It was concerned with the overseas citizenship of India status itself. So the fake news post which was going or making rounds in the social media, it suggested that India is again reclassifying the overseas citizen of India as considered to as foreigners. And as it took many of the people with shock, ultimately it created a lot of uproar. And that is why the Ministry of External Affairs, it came out with a notification clarifying that whatever is being discussed over the fake news post on the social media is false, and ultimately government is not planning to do anything of that sort. And that is why now we have to learn about the overseas citizenship of India and what does that particular mean. So now let us try to start with the objective of this OCI scheme. So the government of India in the month of August 2005, they came up with the Overseas Citizenship of India scheme, which was under the Citizenship Amendment Act of 2003, and it basically provided for increased duration of residence along with lesser travel restrictions plus certain other rights and privileges as well. But for whom this was meant, all these conditions was meant for the persons of Indian origin, or these are those persons who were Indian citizens earlier but now have taken the citizenship of any other country, who were citizens of India, or who were eligible to be a citizen of India on 26th Jan of 1947. And the primary motivation for the government to come up with such kind of scheme, that is the OCI scheme, is to leverage the power of Indian diaspora. That Indian diaspora is extremely well connected, not only in the western part of the world, that is the USA, but also in various other parts of the world, whether it be Africa, Europe, or East Asia for that instance. And India wants to leverage the power of this social capital. And how India can do that? By always maintaining a link, so that this link between the Indian diaspora who has left our country and has taken the citizenship of any other country, and that link has to be connected between the diaspora and our own country. And how that link can be established? That link can be established only by giving this diaspora certain special privileges and particular rights. And what are those privileges, etc.? Now let's try to come to later section. That is, what are the key privileges which are being enjoyed by the OCI card holders? So the first is multiple entry, multiple purpose, lifelong visa to the persons of Indian origin. The second important privilege is with respect to the employment. That is, such certain OCI card holders will be able to pursue professions like doctors, dentists, nurses, pharmacists, engineers, CAs and architects in India. However, these persons or the persons who are holding the OCI card will not be able to hold the governmental positions. Apart from it, they are also getting exemptions from the need to register with the local police or foreigner regional registration office regardless of the duration of their particular stay. Apart from it, they are also treated with parity with NRIs in financial, economic, educational fields, except in the acquisition of agricultural or plantation properties. So that is why these key privileges are being provided to the persons of Indian origins or the OCI card holders, so that the link should be able to be established between the India and the people who have left our country or the Indian diaspora, so that we can utilize their soft power or the talent so as to gain the global leverage in the global world order. Now let us try to see what is the eligibility of attaining the OCI card. or the Overseas Citizenship of India card. So a foreign national is eligible for registration if they were an Indian citizen on or after 26 January 1950, were eligible for Indian citizenship on 26 January 1950, who belong to a territory that joined India after 15th August 1947, for example, Goa. If a person who is a child or a grandchild or a great-grandchild of an Indian citizen person, but who is, since he is not a citizen of a country, of our country, but he is a child or a grandchild or a great-grandchild of a person who was a citizen of our country. Fifth point is if a person who is a minor child of all the above four conditions. And lastly, if a particular Indian person who is a citizen of India and who has married a person who is a foreign national, then that particular foreign spouse will be able to get the OCI card after that marriage has lasted for at least 2 years. Now, what are the important ineligibility conditions which can make a person render ineligible for the OCI status? So, firstly, foreign military personnel is not allowed. Secondly, anyone with parent or grandparent who was a citizen of Pakistan, Bangladesh, or any country specified by the Indian government. Thirdly, OCI applications are not permitted in India on tourist, missionary and mountaineering visas, and the applicant must be an ordinary resident of India. So ultimately, those persons who are on a trip to India on a visa for mountaineering visa or for missionary visas, these people will not be able to achieve the OCI status. Now, what are the restrictions? We already read about and discussed about the various privileges which are available to the OCI card holders. But what are the restrictions? Are there any restrictions to the OCI card holders? Yes, there are. So, the first point is political and governmental positions. So, it is quite obvious that since this OCI card holders are not Indian citizens, but they are, Indian government is trying to draw a olive branch or provide an olive branch to the Indian diaspora, and in providing that Indian diaspora, we are providing certain privileges and rights without providing the citizenship. And since these people are not citizenship, they are not able to hold political and governmental positions. Second is employment limitations. As we already discussed, that OCI card holders will be able to pursue professions of engineers, doctors, dentists, pharmacists, etc. But however, they will not be able to hold governmental positions. Thirdly, passport restrictions. As we already noted, that OCI card holder is not a citizen of India. So they are not having the citizen or the passport of India. However, they are just having the OCI card. And since they are having the passport of their own country, naturally, they will not be having any diplomatic immunity or protection abroad, that is outside India. They cannot claim for Indian diplomatic protection based on the OCI cards. Now, recently, Government of India has included certain rules for the utilization of OCI card holders as well. So, the first is restricted area permit. Now, with the help of this particular rule, what government has done is that OCI holders need special permission to visit protected or restricted areas like Jammu and Kashmir and Arunachal Pradesh. Now, since we know that Jammu and Kashmir is a very sensitive, politically sensitive areas, so government has brought in this rule that all the OCI holders, they will need a special permission to visit such places, because there is a threat perception or security perception that there can be like devious agents can use the Indian diaspora against the national security. So, and the second is special permit for specific activities. For example, OCI must obtain permits for research, missionary work, tablighi activities, journalism and visiting restricted areas, as we already noted in the first point. And then lastly, there has been a change in Foreign Exchange Management Act as well. That is, OCIs were reclassified. Earlier, it were classified with respect to with parity with the NRIs, but now they are reclassified as foreign nationals concerning economic, financial, educational activities under FEMA, reversing their previous NRI equivalent status. So this was the primary change which was brought in with respect to the economic aspect of being a OCI card holder. So Government of India is providing privileges to the OCI card holders in various dimensions, and they are treating the OCI card holders in parity with the non-resident Indians who are Indian citizens. However, in certain areas, the OCI card holders are also provided certain special distinctions, or they need certain special permissions to perform certain activities in our own country. So this was all about this topic. So the next and the last topic for our today's discussion is the Bombay High Court scraps IT rules government fact check unit. So believe me students, this is one of the most important topic of this particular episode, and I hope you will understand it in the best of the spirit. So recently, what is the context? So as we already discussed, the Bombay High Court division bench it struck down certain provisions of information technology intermediary guidelines and digital media ethics code amendment rules of 2023. From now on, since the name of the rule is quite long and it will take a good amount of time to write it every time I need to mention it, I will call it IT rules 2023. So basically, the context is very clear that the Bombay division bench of the Bombay High Court struck down certain provisions of the IT rules 2023, which had led to the establishment of the fact check unit, which was notified by the central government of our country. So it is very important with respect to the right to free speech. Now let us try to understand the core issues which are involved in this thing with the various chronology of the events. Okay. Now, ultimately what had happened in the month of April of 2023, Government of India, to be specific, Ministry of Electronics and Information Technology, had introduced the IT rules 2023, which amended certain provisions of IT rules 2021. And this IT rules 2023 had brought in Rule 3, Clause 1, Subclause B. And what did this Rule 3, Clause 1, Subclause B had provided? That it had provided the Government of India, the authority, to actually constitute a fact check unit. Fact check unit. And as the name suggests, that is, this particular body's primary role and responsibility is to scrape through the data or the volume of data which is present in the social media and actually find out the fake news or which this particular institute considers to be fake. So what was the primary objective of this particular fact check unit? That is, it is to flag content which is available in the social media pertaining to the business of government and which are false, fake and misleading. Why I am writing it in double quotes, that is the pertaining to business of the government, this is in double quotes, and false, fake and misleading, this is in double quotes, because it has been taken verbatim from the Rule 3, Clause 1, Subclause B. And this was the primary function for which the fact check unit had been authorized by this particular rule, that the central government can establish it. Also, the same rule has certain other obligations for the social media intermediaries as well. What are social media intermediaries? Certain prominent examples of SMIs or social media intermediaries are Facebook, Instagram, Snapchat, Twitter, etc., which hosts the content of a third party and broadcast it to the other persons who are on that particular social media intermediary. So what does this particular rule had obligated the social media intermediaries, that as soon as the fact check unit will flag a particular content to be fake, false and misleading within that particular social media intermediary, the social media intermediary will take reasonable effort to put down the flagged content or to remove the flagged content from their platform. Failing to do so, they will lose their safe harbor. What is safe harbor? Safe harbor is a legal immunity which is enjoyed by the social media intermediaries for hosting third party content. For example, there are two persons. Suppose this is a platform, say for example Facebook, and if there is a person, say for example Ram. Now there is a government. Now what happens if Ram posts a very illicit and a very malicious post on the Facebook? So what safe harbor mechanism does is that it is providing legal immunity to the Facebook for hosting whatever malicious content Ram is posting on the Facebook. So government will hold Ram accountable and not Facebook accountable. So with the help of Rule 3 Clause 1 Subclause B of the IT Rules 2023, what government did is that as soon as the fact check unit or FCU will flag any content to be false, fake and misleading, it is the primary responsibility of the social media intermediary or Facebook, Instagram, Twitter, etc. to take reasonable effort to actually take down or remove the flagged content. Failing to do that, the social media will lose safe harbor and ultimately it will lose the legal immunity, so that the government will be able to hold the social media intermediaries also accountable. Now the whole point or the legal question behind this thing is that putting the social media to such kind of conditionalities or arm twisting the social media to actually help the fact check unit which has been constituted by the government is very troublesome. And secondly, what had happened that as soon as the rule, IT Rules 2023 came in the April 2023, on 6th of April, as soon as the rule came out, Government of India constituted the fact check unit. Now similarly, now the various political commentators and the civil rights activists who are very active in preserving the right to free speech and expression, they got startled and appalled by the potential misuse which can be done through the government's FCU. Now what happened, that there is a very famous comedian by the name of Kunal Kamra. He is a very famous comedian and a political satirist. Now he approached the Bombay High Court along with other civil society organizations, and they challenged the Rule 3 Clause 1 Subclause B of IT Rules 2023. Now what had happened, that on 10th of April, Kunal Kamra and party challenged this thing, and ultimately the Bombay High Court provided a split verdict on 31st of Jan 2024. So ultimately there were two judge bench and it provided a split verdict. So Justice Patel were there and another justice was Justice Gokhale. Now since this particular judgment, it involved a greater constitutional issue or very important, deep, pertinent constitutional questions, ultimately the Chief Justice of High Court of Bombay, ultimately it provided this particular pending case to Justice Chandurkar, who had to provide a tiebreaker judgment. And after going through the different facets of the arguments by different petitioners, Justice Chandurkar, it provided the judgment in favor of the petitioners itself. So ultimately, what the Justice Chandorkar observed, we will try to learn it in next section. But before that, we need to understand what are the key legal questions which are involved in this particular issue. So we will be able to understand the key legal issues by examining the petitioners and the responders argument. So who were the petitioners? So the Kunal Kamra was one petitioner. So what the Kunal Kamra and other civil society organizations were arguing, that ultimately the terms which were used, terms used in the rule are very vague, and it provides opportunity for potential misuse. Secondly, they contended that ultimately the fact check unit is the final arbiter of what is true and what is false. So ultimately what these guys argued, that it made government the judge in their own case. The third point that these guys had noted is that there is no safeguard mechanism. That is, any content can be flagged by the fact check unit. And lastly, it provided for a chilling effect on the free speech. That is Article 19, Clause 1, Subclause A. So these were the major arguments which are put forward by the Kunal Kamra and party in front of the Bombay High Court. Now, what did the responders say? What were the government's arguments with respect to the particular issue? The government had said that the fact check unit, whatever the fact check unit the content is flagging, it is advisory in nature. It is advisory in nature, and the social media intermediary, either they can remove it or leave the content with certain disclaimer. With respect to, on the question of no safeguard, the government said that if any individual who is putting the content on the social media platform is getting aggrieved, then they always have the path to approach the court of law, which seems quite unreasonable. Now we can already understand from the line of reasoning of which the government is putting in front of the Bombay High Court, and that is why it is very important to understand what did actually Justice Chandorkar ruled in the cases in the final judgment which the Bombay High Court had provided. So as we already noted that in January 2024, the Bombay High Court has provided a split verdict, that is 1:1. There were two judges, Patel on one side and Gokhale on one side. At that point of time, Patel had favored the petitioners, that is the Kunal Kamra and other civil society activists. However, the judge Gokhale has favored the government. Because this particular case involved deeper questions of constitutional issues, this particular case was the Chief Justice of Bombay High Court had put this case in front of Justice Chandorkar. Justice Chandorkar, so as to provide a tiebreaker judgment. And after going through both the sides of the arguments that we already discussed in the previous header, that Justice Chandorkar actually scrutinized and examined the various arguments and various facets of this case, and it provided a tiebreaker judgment, and Justice Chandorkar provided judgment in the favor of petitioners, and ultimately it struck down the rule 3 clause 1 subclause B, which authorized the government of India to actually constitute the fact-checking unit. Now, what did Justice Chandorkar observed in his judgment? Now, let us try to understand it point by point. So, the first point that the Justice Chandorkar observed is the vague terms which was used in the rule. As we already noted that there was a term called fake, false and misleading. So what Justice Chandorkar ruled is that ultimately these terms is not defined. It is very vague and it has got very high potential for misuse. Secondly, the ruling also noted that it provided a great degree of chilling effect on free speech. How? Because ultimately the person or the content creator who is putting the content on the platform is absolutely on the mercy of fact-checking unit, which is a total governmental agency. And secondly, the social media providers, if they are not taking down the content, ultimately social media platforms will also lose their legal immunity or safe harbor. So this is nothing but an indirect arm twisting of the social media platforms, which is ultimately leading to the chilling effect on the free speech of thoughts and expressions. Third important point which was highlighted by the Justice Chandorkar was that how come the fact-checking unit will be able to objectively identify what constitutes truth. For example, there are certain things in the natural sciences, for example maths, that is 2 plus 2 will be equal to 4 no matter who is reporting, who is writing it. However, there are certain things when we talk about the human or the social sciences or the human conditions where every information can be interpreted in different way, and ultimately how the information is being interpreted. For example, there can be various ways in which human poverty can be described. Not only that, if a poet is writing a poem on the human poverty or deprivation which a particular farmer is facing in the drought prone regions of Bundelkhand, the fact check unit in that case cannot hold that poet accountable just because that poet is trying to describe the poverty which that particular farmer is facing in that area. However, it is amenable to the data which is being provided by the government of India. So ultimately, the fact check unit will try to address or to flag the such data which are not in favor of the government. It will open a door for the potential misuse of it. And that is why the judgment also noted that how FCU or the fact checking unit will assure that it will very objectively identify what constitute truth. And many a times it is very difficult to constitute what is truth in social sciences, because information can be interpreted in various terms. And secondly, the judge also noted that why it is taking care of only the information which is pertaining to government business, and why not take care of all the fake news which is floating in the social media. And thirdly, who will fact check the fact checker? That ultimately there is absolutely no mechanism with respect to who is going to ultimately cross check whether the FCU is doing the right job or not. So these were the important three observations which were provided by the Bombay High Court ruling. The fourth and the last important observation which was provided by the Justice Chandorkar was that the government had contended that even if a person is aggrieved by the FCU's decision to flag their content, they can approach the court. However, Justice Chandorkar noted that government's claim that any individual can actually approach the court of law in defiance of the judgment which has been provided by the fact-checking unit is not a sufficient safeguard. And it is again creating a great chilling effect on the citizens' agency to express their thoughts. And that is why this particular judgment by the Bombay High Court holds a tremendous relevance and significance with respect to the rights jurisprudence in our country. And now what we can expect next in this leg? So since it has been ruled by the Bombay High Court, so definitely the central government will approach the Supreme Court with respect to the further review petition of this particular case. So this was all about this episode of Recitals in Depth for Polity and Governance. Stay tuned for the next month. Thank you.